Welcome to Talk Lytical TV. I'm your host, Lytical J, and I'm back with another logical perspective. Today, we're going to be discussing how the judge in the YNW Melly's murder trial denied the state's motion to amend their notice to intent to seek the death penalty. What all that means exactly, well, we're about to find out. So this document that we're about to dive into is a 28-page document that was pretty much, this is called the motion. Of course, we already know that's what lawyers do. They will kill you with a motion all day. Of course, I guess a motion is you objecting to something the court is trying to do that maybe will be beneficial towards your client, right? So Melly's lawyers put together a nice motion to pretty much convince the judge in this case why they shouldn't go forward with seeking the death penalty in this case. All right, now I'm not going to go through all 28 pages of this particular document, but we're gonna go through the key parts. All right, so first document up on your screen, this is pretty much the first page of this affidavit or motion, whatever you would want to call it, and this first page right here was put together by Melly's lawyer. So let's dive in a little bit. We're gonna read. So motion to preclude the state for seeking the death penalty. All right, so the defendant Jamel Demons, by and through his undersigned counsel, hereby moves this honorable court to enter an order precluding the state of Florida for seeking the death penalty as a possible sentence in this case on the grounds that the state, again, that's prosecution, that the state failed to comply with the mandatory prerequisitions pursuant to Florida Statute 782.041B and Rule 3.181 of the Florida Rules of Criminal Procedures, and as grounds, therefore, the defendant states the following. So they give a little history here, and I highlighted that here for you so you can see. So let's get a little breakdown for people that really don't know what's going on. They kind of do know what's going on, but still a little lost. As I'm reading more and more, I mean, we've all heard from this blogger, that blogger, this news source, that news article, all different types of things. But what I would like to go by as I'm doing this now and kind of just intrigued with this case myself is really just diving into the documents. What we really need to know is there. that's all there is to it. All right, so the history. One, that of February 7th of 2019, the defendant voluntarily surrendered to law enforcement. I'm sure most people knew he turned himself in, and he was on tour or whatever, and he turned himself in. All right, so February 8th, an indictment was filed, and in the case charging the defendant with 2 counts of murder in the first degree with a firearm. All right, and then the third, March 5th, 2019, the defendant was arraigned on the aforementioned indictment, at which time he entered a plea of not guilty, all right, to both indictments, all right, to both counts of indictments, excuse me. Then on April 16, 2019, the state went ahead and filed their notice to the courts to let them know that they were intending to seek the death penalty. Now, apparently there's a 45-day window that the state had to do such thing. Let's keep going. We're going to put the next document up. 5, that on February 8th, 2022, the state of Florida filed a motion to take photographs of the defendant in attempt to document the gang-affiliated tattoo on the defendant as it related to a previously enumerated aggravator to justify a sentence of death. So the state is pretty much trying to throw every little aggravator in there that they can possibly pile on top of the murder charges to just make Melly look as bad, as a demon, as a savage, as a murderer, like they're trying to make sure that they can use every single thing to throw at him to get him this death penalty, right? So skipping forward to number 7, that on February 18, 2022, the state filed a motion for leave. So pretty much what the state was trying to do at that point was say, hey, listen, judge, can you give us a little time? Go ahead and approve this time that we need to go ahead and amend the previous filed notice of intent to seek the death penalty. So of course this case started in like 2019. So back then, sometime in February, the state did file a notice to intent to seek the death penalty. All right. Okay, so then number 8, that on February 24th, 2022, the court denied the state's motion for leave of court to amend the previous filed notice of intent to seek the death penalty, stating that the state has not shown good cause for why it should be allowed to amend its notice of intent to seek the death penalty nearly 3 years after the state filed its initial notice of intent to seek the death penalty, right? So again, these are all of the facts and the angle that Melly's lawyers are coming from, right? This is what they're using. This is all the facts that they pulled together just to show maybe where an error was made or where the state fucked up at. And they did fuck up. Let's keep going. So number 9, that on February 23rd, 2022, the state then went ahead and filed a superseding indictment charging the defendants with 2 counts of murder in the first degree with a firearm, and added that the offenses were committed for the purpose of benefiting, promoting, or furthering the interests of a criminal gang, contrary to section yada yada yada. Y'all already see that on the screen. All right. And then number 10, that on or about March 2nd, 2022, at the court's instruction, the defendant was arraigned on the superseding indictment and stood mute. He said nothing. He didn't. YNW Melly, when they told him about the new superseding indictment, he stood mute. He had nothing to say. He didn't plead guilty or nothing. And the court entered a plea of not guilty to both counts of the superseding indictment. The court entered the plea for him. He didn't say anything. All right, let's pull up the next document. Number 11, that on March 4th, 2022, the state filed another amended motion to take photographs of the defendant, alleging for the very first time that it would require the tier of fact to determine if the defendant is a member of a criminal street gang, and that the charged offenses benefited, promoted, or furthered the interest of a criminal gang. Number 12, March 16, 2022, the defendant filed a response. So that's them saying, the lawyer, Melly's lawyers, filed a response to the state amended motion for the photographs, alleging that the state's motion on its face is improper and such motion should be stricken, since you cannot amend a motion after it's been ruled upon. Okay? All right, so what they're kind of saying right there, Melly's defense is saying right there, like, hey, the judge already ordered on this motion for you guys to go ahead and take these pictures, but now you want to come back and say, oh, I forgot, let me amend the documents, this motion, let me amend the motion to now add the fact that we think he's a gang member, and this is the reason why he killed his two friends to benefit and promote that's so stupid. Because what about the $200,000 ploy? Like, they need to pick one. But this is what I'm saying, like, the state has a lot of holes in their case, but that's another video. All right, so number 13, that on March 31st, 2022, during a hearing on the state's motion to take photographs, the state said that it is now traveling under a new indictment and that the defendant alleged gang affiliation is now relevant during the guilt phase of the trial. Number 14, that on April 1st, 2022, the court granted the state's motion to take photographs of the defendant, stating in part that the defendant's gang affiliation is now relevant for the first time. Out of this whole time they've been going through this case, this is the first time they know they're gang affiliated. It's clear to see. We all know that. But at the same time, that was not the angle that the prosecutors were using. They weren't using that. So come now, maybe it's a tactic or whatever. Come now, we're getting ready to get close to trial. They're trying to throw all these different things in there and try to see what sticks. I mean, that's what prosecutors do. Like, they play dirty. That's pretty much what they do. All right, so let's move on to the last part of that section, and that would be so yeah, let's just run back through again. So on the 31st, during the hearing, the state motion to take the photographs, and they said they're traveling on the new indictment. April 1st, 2022, the court granted the state's motion to take said pictures, right? And they were kind of agreeing with the state that, hey, yeah, he's a gang member. We can use that now. So number 15, that the state never filed its notice of intent to seek the death penalty and provide the notice of aggravating factors which the state intended to prove beyond a reasonable doubt if the defendant is found guilty of the aforementioned charges set forth in the new indictment. All right, so that's kind of where the defense, Melly's defense, is coming from. Just kind of giving you a breakdown of all of the motions that we're putting from the state themselves and the I guess the decision of what the judge would have made upon those said motions. All right, so now on the screen we have the legal argument. This is pretty much the whole argument and drive and angle from where Melly's lawyers are coming from, and it's just one really that sticks out, and it's saying that since the 45-day notice of intent to seek has expired, the state should therefore be stopped, precluded from seeking the death penalty in this case. So initially, when they filed the case in 2019, they had a certain amount of time, we now know 45 days, to say, hey, we also want to throw the death penalty in there. We also want to throw all these aggravators in there to show that he's a gang member and such. But for whatever reason, they didn't do that. Now, the state does have a reason on why. They have a reason. Now, the reasoning is not a bad reasoning at all. The reasoning it actually makes sense. Here you have it on the screen now, where we have the judge denying the court order to amend the previously filed notice of intent to seek the death penalty. So we're going to read a little bit. Order denying the state's motion for leave of court to amend previously filed notice of intent to seek the death penalty. This cause came before the court on the state's motion for leave of court to amend previously filed a notice of intent to seek the death penalty, filed on February 18, 2022. A hearing was held on the motion on February 22, 2022, having considered the state's motions, arguments of counsel, the court files, applicable law, and otherwise being fully advised, the court finds as follows. The court has the discretion to allow the state to amend its notice of intent to seek the death penalty upon showing a good cause. The court finds that the state has not shown good cause for why it should be allowed to amend its notice of intent to seek the death penalty, nearly 3 years after the state filed its initial notice of intent to seek the death penalty. The state alleges that this is the part where we find out why they weren't able to file that motion within the 45-day window that they're allowed. So the state alleges that it waited to move to amend its notice because it did not initially have sufficient evidence to exclude co-defendant Cortland Henry as the shooter. However, the state has had sufficient evidence that defendant was the shooter for some time now. Well, allegedly, right? That would be Melly. Let's read that again. However, the state has had sufficient evidence that the defendant was the shooter for some time. The state have all kinds of things alleging that it would be pointing towards Melly and not Cortland being the shooter. They did a forensic on his hands. There was no gunpowder or any type of residue found on YNW Cortland Henry, aka Cortland Henry. So the state is bullshitting. But I could kind of see where that angle could have worked if the judge wasn't paying attention. Good thing the judge is paying attention and he's like, listen, fuck out of here. Y'all had enough time. Y'all already off rip is saying Melly. So with that being said, you knew for a fact in the beginning that Cortland wasn't the shooter and you had sufficient time. So this is the judge saying, however, the state has had sufficient evidence that the defendant was the shooter for some time now. The state also argues that it waited to move for leave of court to amend its notice of intent to seek the death penalty because it was waiting for the defense to provide evidence in support of mitigation. However, defendant is entitled to notice of the aggravators the state intends to pursue regardless of whether he submits any evidence in support of mitigation. And the end is just showing you that this was ordered by Andrew L. Siegel, the judge that's overseeing the case. They denied. So based on the above, it is ordered and adjourned that the state's motion for leave of court to amend previously filed notice of intent to seek the death penalty is hereby denied. Okay? Denied. So with that being said, kind of just taking it back a little bit to Melly's lawyer's defense is that they should get that the fuck off the table, right? They should take that off the table, that for the fact that you have 45 days, you didn't do what you needed to do in 45 days, then if the prosecutor intended to seek the death penalty, then the prosecutor must have given notice to the defendant and filed the notice within that time frame. So the judge got that out of here. So my thing is now, I don't really see anybody really reporting on that. Yes, you know, the lawyer's putting in a lot of different motions. Some are being denied, some are being approved. But I feel like this is one of the biggest ones that, you know, it should be looked at. Even if they do find him guilty, if the death penalty is off the table, they won't use that in the sentencing. He'll just be sentenced to, you know, of course, life. I guess that's better than, you know, dying. You spend the rest in the eyes of his defense. That would be better to get the death penalty off the table. That way, if they do blow trial, he's not up for the death penalty. He'll just be sentenced under the guidelines of capital murder, or, you know, whatever they end up charging him with at the end of the trial. Yeah, so let me know what you guys think down in the comments. I think that this is a pretty good move for Melly, in a sense, just having that off the table. Now, as far as all of the other motions, we'll have to get into another video, but people raving about, oh, well, you know, they're not going to use the Twitter stuff. Well, I mean, I kind of saw what's in there, and it wasn't really much in there to use anyways, you know what I'm saying? It's a couple of things here that's suspicious or whatever, but it's nothing like what is like the Instagram stuff, like the Gmail stuff. Like, that stuff is the stuff that's going to get you. So yeah, that might be a good win or whatever. That's one less thing for them to use to present to the jury, but at the same time is not one of the strongest things that could have been blocked from being displayed to the jury as well. All right, so let me know what you guys think down in the comments. That concluded the end of this video. Thanks for watching. Don't forget to subscribe, comment, and like. Bye.